We are in the jail, Lord.
Since when there is that
During vacation, Lord,
during
there are some benches.
I
They have to mention my lord otherwise. So, today is 32 days, Lord.
32 days, no? I think that the Lord may consider for his grant of bail at this
No, my
stage.
lord. Without the case diary, my lord.
It is of course true.
That the part you have to go.
Yes, that is the problem.
Immediately after vacation we are listing it on
ठीक है सर, immediately after vacation,
16/7.
we mention कोई
Now it that
Yes.
may be listed in the vacation.
We shall make a mention during the vacation period.
Step to no.
आज स्टेप फुल हो जाएगा.
Step to no.
Court opinion, bail application, Lordship. Lordship, I am behind the bar more than 3 years, Lordship. Offence under section 20B2C and 29 of NDPS Act, Lordship. Out of 9 witnesses, Lordship, as per my information, only 2 witnesses has been examined, Lordship. Lordship, at this stage, Lordship, call for the scanned copy of the LCR, Lordship, along with the order of the
Yes, Lordship.
NDPS
Copy
case,
of case record may be called.
We are listing it immediately
after vacation, Lordship.
or 7/7.
Must oblige,
Highly
Lordship.
unlikely.
May I please, Your Lordship? Lordship, this is a regular bail petition. Matter pertains to section 21B 29 of the NDPS Act, Lordship.
But it's certainly.
Lordship, the FIR is at page number 23, madam. With reference to the subject cited above, I have the honor to report that today at 2:20 p.m., being received a secret information from a reliable source that a drug peddler named Anishur Sikdar has been moving at 3 number Balabari Char Bazaar. On receiving the information, the matter was informed to OC Mornoy PS and a team was formed and necessary permission was taken from additional SP Crime Golpara for executing the operation. Accordingly, a team was formed under the leadership of Honorable so-and-so party, and it was immediately proceeded to location at 3 number Baladmari, Char near Anayal Bazaar, along with NDPS kit available in the PS. Being reached at the PO, we have conducted search and trace out the suspected person. As per our information, we have found their available witnesses, namely so-and-so, and informed them regarding the purpose of our search and requested them to witness the search, to which they agreed. Being traced out the person, namely Ashikur Rahman, from 3 number Baladmari Char in front of Ziaur Rahman's house, we have notified him by the provision of under section 165 CRPC and 50 NDPS Act and conducted physical search to him. We have offered ourselves to be searched before body search and apprehend this person in presence of witnesses. During the search, we recovered 42 vials of suspected heroin weighing 45 grams with the vials and 6.13 grams without the vials, which is intermediate quantity minor, and seized from the person, possession of the accused, transport red-handed person in presence of seizure cum PO witnesses after measuring with the NDPS kit containing digital weighing measure scale and packed and sealed under the supervision of Ayan so-and-so, as it was empowered, him being APS officer, police.
Whether the part are it's better already done.
The interesting part is, my lord, the petitioner moved a petition in the Honorable NDPS Special Court in Golpara. That being said, it was filed under 437. So, I'm coming to the order, my lord. It is the next day. The only ground of rejection of that bail petition was that a part searches was filed by the IO, and at the same time, in that order only, Honorable Court, the court below, directed the IO to file the remaining part. In a sense, it was clearly written in the order, it is clear, that the IO should be submitting the charge sheet in a proper form, my lord. And in today's date, my lord, on the day when this particular case was filed, the petitioner, his father, in fact, he applied for a certified copy of the part charge. It was learned from that particular copy petition, my lord. It is in fact written on that copy petition that part charge sheet is no more available in the record, which means the entire charge sheet, which was submitted in part, was returned to the IO to be properly submitted again. Facts remains, my lord. In today's date, there is no charge sheet at all in the case record. For that, my lord, order may be taken up. I'll be coming to them. It is at page number 30, my lord. Lofty, maybe please to take up 31, second para records. Records reveal accused was arrested on so and so. Since then, he was inside the jail hazard. Further, the suspected contraband items were already sent to FSL, Kahili Para, and result is yet to be received by the IO. Prima facie, there is incriminating material against the present accused regarding his involvement in the incident case, and the IO has already filed the part charge sheet within statutory period of 60 days. Considering all these aspects, as the IO part charge sheet within the statutory period of 60 days, hence I am not inclined to grant bail to the present accused in this stage. Accordingly, the bail prayer of the accused so is rejected. Return the case diary along with the copy of this order to IO for his necessary information through learned PP. Further, IO is directed to file part charge sheet in proper form as per procedure of law. My lord, maybe please should take up page number 33 now, my lord. This is the copy petition that the petitioner has filed, his father has filed. But if your honor peruses the last part, left side, your lordship. Yes, charge sheet is not in record. It was returned, which means, my lord, it is clear that although there was a part charge sheet before, on the day of passing of that order, it was returned for directing the IO to be properly submitting this thing, the charge sheet. So as of today, there is no charge sheet in the record.
No, my humble comment, there is no concept of part charge sheet in matter. Because as per matter 167 CRPC matter or 173 CRPC matter, the police can investigate it further also. In this case, my lord, admittedly, my lord, as effective from the order dated 31/5/2024, my lord. So that is page number 31, my lord. But considering all these aspects, the IO filed part charge sheet within the statutory period of 60 days. Hence, I am not inclined to grant bail to the present accused at this stage. Accordingly, bail period of the accused unless signature is rejected, my lord. And the problem, my lord, this charge sheet was filed without the FSL report, my lord. What I have, my lord, in the above paragraph it is mentioned, my lord. Because, my lord, further the suspected contraband items were already sent to FSL Kalipura, and result is yet to be received by the IO, my lord.
May I, my lord?
And, my lord, in this regard, my lord, there are Supreme Court judgment, my lord. Without the, my lord, FSL report also, my lord, charges can be filed, my lord. Charges can be filed. So, my lord, in this case, my lord, since, my lord, admittedly, charges has been filed, my lord. So, let the screen copy be called for, my lord. We'll examine the screen copy. Otherwise, my lord, he has completed, my lord, 60 days, my lord. It's an intermediate quantity, my lord. And he has completed 60 days. But what reason, my lord, the charges has been returned, my lord? That will affect on the case diary, my lord. Screen copy of the case diary.
Go by the order, charge sheet was filed.
Charges filed, my lord.
And it was, the order was passed that part charge maybe subsequent, after subsequent, the part charge may be filed in a proper form. Why not able to see this report at the why the entire part charge sheet was returned?
That will go,
or
will
there
examine
may be
the
some technical thing is maybe there for correct return or but fact is that the charge sheet was filed. That was perused by the court and the accordingly order was passed.
My lord.
That there is no dispute about
The
it.
probably, my lord, in the above paragraph, it was mentioned that my FSL report was not received, my lord.
FSL was not.
Not
The
received,
charge
my
sheet
lord.
was otherwise filed.
Otherwise, my lord, within 60 days, my lord. So we'll examine the, my lord, scan copy of the, my lord, record, my lord.
Because yes, any other subject from your
Yes, my lord. I beg your lordship to take up para number 8 of my petition, page number 8.
Yes.
Now, if this contention is to be considered, my lord, that part charges has been filed, I would like to refer Ritu Sabaria versus
you have
Union.
already mentioned.
Yes.
Yes.
So, these cases I have referred, my lord. I have mentioned in this in my petition itself.
But this case and the present case, a bit different in the sense it was already charged. But subsequently what has happened or what is 167, 167 you are,
Yes.
I mean, here in case it's not about one but in our case, it's different, I think. So
No,
it
my
was
lord.
more
My lord.
otherwise, proper, I don't know why started is not available.
Yes.
But you definitely started
Yes,
was
yes.
not available.
Yes, yes.
Let us acquire that not
Yes.
pocket passport and obviously we don't have time. In fact,
Yes.
Friday it does
Yes.
come otherwise after vacation.
Immediately after vacation.
Because there will be some order
But my lord, he is 84 days in custody as of today, my lord.
as of
Yes.
but for
Yes, from these documents.
till Friday may not be reached, I think. That's what.
My lord may
Friday
fix
I will not,
my lord may fix the matter, lordship, at least if required.
Friday it's not possible. Friday already. Because all developers and all they are living on Friday night. So we don't have time. So that is one problem. Other matters are also the opportunities are there. So it has to come from which court? Which
My lord?
district?
Golpara, my lord.
Walford.
Special judge Balpura.
It is the
Vacation for the then lordship.
vacation. We cannot fix it.
Yes, my lord, we can.
Do one thing. We were calling for the case that we make a mention over in the vacation court.
Yes.
It will be and the first and second or second or
Second.
second and third.
Second time.
Second and third. Make a mention. If either time suppose the case that we you just send the signal today itself, it may reach. If
No,
it
madam,
reaches,
that-
then you can make a mention.
Then the scan will be called for, my lord.
Definitely, scan copy. We are calling for scan copy of the case record along with the case that may be on or before second or third.
But
In
the
that
charge sheet
case-
itself is not in court, my lord. That is the problem.
That's why we are calling for the case
Okay.
record. And you make a mention to the vacation pay if it reaches.
My lord.
Or otherwise, the more days are there. 11, 12 are also vacation. So either.
Right.
Otherwise, that rate we have that is subject to charge. Not available.
Yes.
Obviously,
Yes.
charge
Yes.
not.
I give the blood.
Yeah.
May I please, Lordship. My Lord, 33 days in custody, Lordship. The petitioner, there are 3 petitioners, Lordship.
Oh. That's anyway, yeah.
Yes, Lordship. There are 3 petitioners. They are 33 days in custody. Allegation under section 8 and 12 of the POCSO Act, Lordship. Lordship may kindly find the FIR at test 10, Lordship.
Mr. Korba,
My lord.
what matter was there? The same thing. Some boys came and
Oh, brother, my
some
lord,
videographer one.
my lord, it is to same case or not, my lord.
It's same
My lord, that is different, my lord.
that is they were bound some act.
Yeah.
Here,
In this case, my lord, they were forced, my lord. In other case, they were forced
yes.
to indulge in some activities. In this case, my lord, they were assaulted, my lord.
Actually, they tried to discuss the mob, Lordship. The mob which tried to assault the victim girl and his boyfriend, Lordship. these three person tried to dispatch those person, Lordship, and some unknown person videographed the situation, and the informant seeing the videograph lost this FIR after 14 days, Lordship. After 14 days from the...
The position, suppose, but you are all at the FIR. How
Yes, Lordship, that's true.
you are engaging yourself only to disperse the mob, but your name is still.
Yes.
Notice also will be required, my lord.
It is also mentioned in the FIR, Lordship. After going through the FIR, these people are identified. After going through the videography, Lordship. Lordship, may kindly see the last line of the FIR.
Videograph.
Yes, Lordship. The informant saw the videograph, and thereafter these three persons were implicated, Lordship. Actually, these three persons tried to disperse the mob, Lordship, which attacked the victim.
In the case of the prisoner,
Yes. 100. Yes, sir.
one thoroughly just to tell you the phone number.
Shahir Ali, respondent number 2 is the informant, brother of the victim, Lordship.
Or what early day.
Lordship.
Yes, yes.
My focus is saying that 27 be
Lordship, early date, Lordship. 16, Lordship, already 33 days, and election 16.
7 also.
Yes, Lordship.
And you take case for eating not.
Lord.
Please take note that
Oblige, Lordship.
approval.
What?
May I please, Lordship? My Lord, decision 482 application, my Lord. My Lord, quashing of some orders whereby the learned trial court has passed and issued NBW against the present petitioner, my Lord. My Lord, the stage of the proceeding, my Lord, at the appearance stage, my Lord. And I have stated in my petition in paragraph number 6, my Lord, that the petitioner, my Lord, the proceeding is at Nagaon, my Lord, Koliabor, SDZM, my Lord, pending, and the petitioner is a resident of Kasar, my Lord. And he remains outside from his house, my Lord, for his business purpose, my Lord. As though someone was served to his house, my Lord, he has no knowledge about this pending of the proceeding, my Lord. So therefore, my Lord, the NBW was issued against the present petitioner, and he approached before this honorable court by filing this petition, my Lord. He is willing to appear before the court below, my Lord. The prayer before the Lordship, my Lord, that
Have you any order?
yes, my Lord. My Lord, it starts from, my Lord, page number 28, my Lord. 29.
Your petitioner is
Nizamuddin, my Lord. Now, my Lord, next date is, my Lord, on 12/8/2024, my Lord. He will appear, my Lord, within a period of 10 days, my Lord. Page 31, my Lord.
Yasuddin appear.
My Lord, there are three accused persons, my Lord.
No, yes, you are Nizamuddin.
Nizamuddin, my Lord.
But one Yasuddin was also there against whom the NBW was issued, but he subsequently appeared.
Yeah, my Lord.
So his prayer is considered. Huh?
My Lord.
You have also appeared.
My Lord, Ghiyasuddin, my Lord, he earlier appeared, my Lord. And thereafter, on last occasion, my Lord, 18/6/2024, he again appeared, my Lord. In between, NBW was issued, my Lord, against him, my Lord.
NBW is like only page number 18. Sorry.
My Lord, on 9/2/2024, my Lord. Now, my lord, on last date, my lord, is on 18/6/2024, my lord. When I came to know, and I immediately applied for the certified copy and filed this petition, my lord, before this honorable court, my lord. I will appear, my lord.
Lordship may come to my lord, page 29, my lord.
Yes.
Page 29, my lord. The accused, third paragraph, my lord. Accused Nizamuddin is absent. Someone served and returned with report, my lord. In spite of receiving someone, he is not appearing. That's why, my lord, trial court is told no NBW.
My lord,
And obviously, the appeared court is done after, even after issuance of NPW, because one gas period also is considered.
Consider, my lord. Let him appear, Lordship. Otherwise, it is not no way, my lord, keeping pending, my lord, keep pending this matter.
But, whereby one on one that however not available. But what about this summon? What you want to say? Because per
My lord-
order, summonses were already served.
yes, my lord. Therefore, my lord, I plead for the para 6 of my petition, my lord. I have stated, my lord. The petitioner has no knowledge, my lord. So some family members may receive, my lord, as he remains outside for his business purpose, my lord. And therefore, my lord. Okay, right. My lord. My lord. Highly obliged.
May I please your lordship? Lordship,
This is an application under section 482 CRPC, Lordship. The petitioner before your Lordship is the wife of the complainant. They got married on 26 June 2023, last year. Just 1 year, Lordship. So, their marriage ceremony was solemnized at Tinsukia. And after their marriage, they started living at Tinsukia in a rented flat. The original house of the complainant is at Jorhat. And the wife is at Tinsukia, Makum. So after marriage, they started living at Tinsukia. And after living for 1.5 months, they get separated. Some disputes arises. One complaint register case has been filed against the husband. That is, the petitioner filed one complaint register case. Now I am before your Lordship for quashing of the complaint register case filed by the husband at Jorhat against his wife, who is staying at Tinsukia. The first primary question is that, Lordship, their all belongings are at Tinsukia. After 1.5 months of their separation, they started living, the husband at Jorhat, and the petitioner before your Lordship is at Tinsukia. So, Lordship, the Honorable Additional Chief Judicial Magistrate at Jorhat has taken cognizance of the offence, and he registered a case under section 403 IPC. Misappropriation of movable properties by the wife, Lordship. That is the section in the IPC. So, Lordship, I'd like to take your Lordship to page 13. It is the wife, Jyoti Sharma. Her permanent residence is at Tinsukia. They were living at Tinsukia, Lordship. That is her Aadhaar card. Then the complaint petition is at page 14, Lordship. That is the complaint petition filed by the complainant, that is husband, against his wife. And, Lordship, may come to page summons to the accused, that is at page 17. That is issue of process, Lordship. Page 17, Lordship, may come to that page. And cognizance under section 403, that is page 23. And accused was absent on the first date, that is 15th May, with steps, which was allowed by the Additional Chief Judicial Magistrate, Jorhat. Now, your Lordship may come to page 7 of my petition, paragraph 6. I have explained the law, Lordship. Everything here, Lordship. That it is stated that a perusal of the complaint of CR case number 700 of 2023 reveals that the offence alleged was committed at Tinsukia. And as per section 177 of the Criminal Procedure Code 1973, every offence is required to be tried by a court within whose local jurisdiction it was committed. So there is no jurisdiction on the part of the Additional Chief Judicial Magistrate to try a case where the cause of action arose at Tinsukia, Lordship. That is section 177. Then, your Lordship, may come to next line. Further, the accused petitioner is a resident of Tinsukia district, and as such provisions of section 202 of the Code of Criminal Procedure 1973 were mandatory on the part of the learned Additional Chief Judicial Magistrate. Lordship, may kindly come to section 202 CRPC. Here it is a mandatory provision, Lordship. He has undermined that provision, that Additional Chief Judicial Magistrate. So, Lordship, may kindly come to here, postponement of issue of process. Section 202, subsection 1. Any magistrate on receipt of a complaint of an offence of which he is authorized to take cognizance or which has been made over to him under section 192 may, if he thinks fit, then, Lordship, within the bracket, and shall, in a case where the accused is residing at a place beyond the area in which he exercises his jurisdiction. That is very much important, Lordship. because he shall, that learned additional chief judicial magistrate shall, in a case where the accused is residing at a place beyond the area in which he exercises his jurisdiction, postpone the issue of process against the accused and either inquire into the case himself or direct an investigation to be made by a police officer or by such other person as he thinks fit for the purpose of deciding whether or not there is sufficient ground for proceeding. So he has already issued the process, Lordship. So on that is the mandatory provision, Lordship. Lordship, with your Lordship knowledge, can very easily acquire it. So, then Lordship may come to paragraph 7 of my petition. That it is well settled principle of law that cause of action having arisen within the jurisdiction of the court where the offence was committed could not be tried by the court where no part of offence was committed. So on the factual scenario disclosed by the complainant in the complaint, the inevitable conclusion is that no part of cause of action arose at Jorhat, and therefore the magistrate concerned has no jurisdiction to deal with the matter. Therefore, the proceedings in complaint case number CR 700 of 2023, pending in the Court of Learned Additional Judicial Magistrate, are liable to be quashed. So at this stage, your Lordship, I have a humble prayer that your Lordship may kindly issue notice to the respondent number 2. And in the meantime, your Lordship may stay the proceeding that is pending in the Court of Learned Additional Chief Judicial Magistrate at Jorhat. That is my humble prayer, your Lordship. And Lordship also, your Lordship may recall and suspend the operation of the impugned order dated 02/03/2024 and other consequential orders passed by the Learned Additional Chief Judicial Magistrate. So this is my humble prayer, your Lordship. May issue notice to the...
My lord, here the complaint case, my lord. Here, Lordship may at this stage call for the notice, my lord. Notice and Lordship may consider after receipt of answer, my lord. My submission is that.
This is Lordship, he has undermined the mandatory provision of section 202, Lordship. That is mandatory. So your Lordship may... Yes, Lordship, that is...
Suppose if there is a restriction, so by the file a application for transfer.
Transfer petition, they may transfer.
Say that.
But this is Lordship mandatory provision, so I am before your Lordship to stay the proceeding presently, Lordship, till the next date at least, Lordship.
Common fact. Case number
CR case number 700 of 2023, pending in the Court of Additional CJM, Jorhat.
okay.
Lordship, state the proceeding. I am deeply obliged.
May it please your Lordship. My Lord, this is a criminal petition filed under section 482 for quashing of an FIR which has been registered at Judnoy PS case number 33 of 2024. My Lord, the facts of the case is both the boy and the girl are major. They have filed an application for marriage and that is pending. Statement of the girl has been recorded, my Lord, which we will draw my Lord's attention. Bail application was filed on behalf of the petitioner. Bail was granted, my lord. Your lordship will kindly first see the FIR at page 12. And the relevant type copy is at page 14. This FIR was lodged by the mother of the alleged victim girl, my lord. With due respect, I would like to inform that on 26/4/2024, my daughter went to Dudnoi College and came to know that one person, namely so-and-so, has kidnapped my daughter from Dudnoi College. After searching thoroughly, it is true that the accused has kidnapped. Therefore, requesting you to recover my daughter and hand over to us after investigating matter. The boy is also a student of Royal Global School at Guwahati. Now, your lordship will kindly see the order at page 18 passed by the learned court below. CR is received with prayer to record the statement of the victim under section 164 of CFPC in connection with Dudnoi PS case number so-and-so. Victim is produced before me. The victim is accompanied so-and-so. I have recorded the statement under section 164 CFPC after giving the victim a reflection of 2 hours. The victim has deposed her statement without any force, fear, inducement or threat. I certify the same. Let a copy of the statement under 164 CFPC be handed over to the IO immediately for the purpose of investigation. The IO specifically directed that the contents of the statement under the sentence should not be disclosed to any person till charge sheet report under section so. The victim has stated her age to be 21 years. Record also reveals the same. As such, she is a major. Accordingly, the IO is directed to allow the victim to go to her choice of destination after verification, obtaining a bond of rupees 2,000 to the satisfier, send back the same. Now, the victim age certificate is at page 20, my lord. Alleged victim, my lord. It is 10/9/2003, my lord. Date of birth at page 20. So, she is a major. And this is the joint application filed for the marriage, that is at page 21, 6/6/2024. Then the accused petitioner approached this honorable court for grant of pre-arrest bail. That order is at page 22. Paragraph 5 may kindly be noted, my lord. So, anticipated bail was disposed of, my lord. 25 and 26 are the identity proof of the girl and the boy, my lord. So both are major. There is a consensual love relation. Application for marriage is pending. So, my lord, there is no question of kidnapping any girl, my lord.
Why to file joint application?
My lord, the joint application for marriage, my lord.
No.
Which one?
This petition has been a joint petition.
No, my lord, because the FI is directed against me, not against the. No, my lord, since the FI was directed against me, not against the daughter, so I have filed it, my lord. And the daughter's application for marriage and all I have annexed. If the allegation was against me.
The case is not started.
No.
My lord, here, at this stage, Lordship may call for CD at this, my lord, notice be issued, my lord. And, my lord, although they have 160, it is also necessary to go to the 164 statement also, my lord. Here, although, my lord, it was marriage application was 6/6/24, my lord, Lordship is also rightly pointed out, my lord. They may find joint petition, so that we are clear that both of them has consented for the criminal petition and also marriage, my lord. At this stage, my lord, I prefer, my lord, only notice and call for the CD, my lord. After receipt of CD, Lordship may consider,
My only humble prayer is, my lord, since the FI is directed against a particular accused, it is not against my would-be wife. Not necessary to include her. If she has some interest, she can always participate in any criminal proceeding. That is always there. But I did not make ask her.
No bar, I think.
Yes.
Joint petition, my lord.
Yes.
Disclose the identity as
Yes.
a victim only.
Yes,
Okay.
And my lord, my respectful submission is that although I am protected by the interim bail of this honorable court, but still I am facing threat and all from the police also to in this case, my lord. So I will pray, my lord, till that case diary reaches this honorable court, no coercive action shall be taken against the petitioner.
No, my lord, no coercive action.
Why? Why, my lord? Why?
My lord.
Why it is not required? Coercive action should not be taken against the accused petitioner.
My lord, he is
I am on bail, but still they are threatening me. Last Sunday I went to the police station. They tried to create an unpleasant situation there in the police station also. I am not asking anything which is not impermissible in law. Is this I am asking for an order that not to take coercive action is impermissible in law? So far this case is concerned, my lord. How can my learned friend object it? My learned friend is not only a public prosecutor for the state. He has also to see that just because we belong to two different community, he will come and say that I am not entitled to not to a coercive action from this court, my lord. With utmost respect, I submit, my lord. I may kindly be this order may.
Community accepted.
My lord. My lord.
Different community accepted does that.
My lord.
No, he said that not to take coercion. But is this not impermissible? Is this impermissible in law? Am I making a prayer which is alien to this court, my lord? Yes.
My lord.
No, he is my lord, objection
This is
should
my
not be.
submission,
My
my
lord,
lord.
objection should not be for objection's sake, my lord.
No.
With utmost respect, my lord. Objection should not be for objection. If I ask something which is alien to the law, which is unknown to the CRPC, then my friend can object to it. I'm obliged, my lord.
He is already in interim, my lord.
No, not interim, absolute bail. You
Then
can.
for
By
J.
by order by because they part of the case that
my lord, my lord.
after vacation.
After vacation, my lord. 23rd, my lord.
My lord, may I pray on, my lord, 24th, my lord, 23rd, I think, as. Oh, my lord, I'm sorry, my lord. May I pray it on 19, my lord?
One.
One line.
One.
We are blessed, my lord.
May I please your lordship? Lordship, this is a 482 application, lordship. Impugn order is on page 25, lordship. Actually, lordship, NBW has been issued against our petitioner, lordship. So this has been, lordship, NBW has been issued due to mismatch of father's name and address, lordship. Page 25, lordship, annexure 4. Order dated 28/5/2024.
How can you come to know that NBW is already...
Actually, thereafter, lordship, service was done, lordship. Earlier order I have annexed, lordship, that is annexure 3, page 23. Operative portion is on page 24, lordship. The IO is found absent, who was called to provide the father's name and proper addresses of accused Sujal Ali and Syed Ali. Issue fresh notice to the IO, lordship. Lordship, after the IO served, the notice summons were served, lordship. After that, directly NBW has issued without issuing, lordship, bailable warrant of arrest. My only humble prayer is, lordship, that
You are SR.
I am Syed Ali, lordship. Against whom, lordship, NBW was issued.
You are just an absconder, Commander, at that time,
Yes,
Commander. In the search it shown as absconder, Commander.
In the charge sheet also, no father's name, nothing has been given. In the charge sheet also, lordship. Only 2 names of the absconders that are
So what
reflected.
you plead that you have not received any summons?
Yes, lordship. Summons, lordship, I have received summons that is reflected in the order in annexure 4, lordship. The summons issued to accused Syed Ali has returned after service, but has failed to appear today. Lordship, that I got after, lordship, proper names of my father and my proper address, lordship. That I have received. But, lordship, before appearing only NBW was issued. It is non-appearing. Lordship, he is a working outside of Assam. That is the problem. Lordship, he is ready to appear, lordship, if given a week time and if it is kept in abeyance, lordship. My only humble prayer.
My lord, here is also, that is also complaint case, my lord. TR case, my lord. It is TR case, my lord.
Yeah. Lordship, actually, case has not been committed, lordship, but it's a 302 Sessions Tribal case.
Yes, no, no, TR case.
Here, case.
My lord, not. GR.
Yeah.
In the order, my lord, 25, it was not mentioned. Someone issued to the accused Syed Ali has
Yes.
returned after service.
Yes, lordship. That
But
is on
failed
page
to
24.
appear today, my lord.
Yes, that is on page 24, lordship. The earlier order, lordship. That has been reflected.
Earlier they have done. Earlier order page 23.
24.
Name is there was some
Next one.
the father's name and proper the Syed Ali.
My lord.
The
Proper
father's
name.
name was
My lord, maybe. My lord.
for it. But what part? That is very good. That is good. Come. Then, if that is very good. Bye.
After appearance, the court below will consider as per law.
Yes.
Minor.
Lordship.
15 days.
Lordship. Obliged. Deeply obliged.
May it please, Your Lordship. To 482 application, we challenge FIR, charge sheet and the order dated 4/6/2024. Lordship may kindly come to page number 46, that is the charge sheet. Lordship, page number 47, point number 9. Here one birth certificate is mentioned that one original birth certificate so and so issued from Morigaon Police Station, Morigaon Civil Hospital by serial number 02881681. This is the birth certificate seized by the police. And the birth certificate which has been adduced by PW2, in this case, Lordship, the serial number is different. That your Lordship will find, the birth certificate your Lordship will find at page number 55, extra 8. Here the serial number is, Lordship, different from the one which is seized by the police during the time of investigation. And also, Lordship, if your Lordship go through the examination of MO, the medical, the X-ray report of the victim from the medical examination is also missing from the record. Therefore, Lordship, the age of the victims has not yet been established by the prosecution, and the prosecution evidence has been closed on 21/5/2024. In this case, Lordship, there are 9 witnesses proposed by the prosecution. Out of 9, prosecution choose to examine only 6 witnesses. including victim. And there are three independent witnesses, that is the father, brother and the mother of the victim. Father PW2, who is the one who adduced the fake birth certificate in the case, and the mother and the brother in their examination, she stated that it was the victim who have taken the permission from them to go to the Guwahati. FIR, Your Lordship will find it page number 38. The allegation is that his daughter was.
Your prayer now.
My lord, here search sheet submitted. My lord, then evidence also, prosecution witness also closed. My lord, evidence also closed. My lord. My lord. Next, that is.
Actually, Lordship, we have filed an application under Section 232 CRPC. Since there is not even iota of evidence against the accused person to substantiate the charges levied against me. Therefore, we filed an application under Section 232. But we have not been provided an opportunity to argue on that. Instead, we have been asked to enter into the defense after recording my statement under Section 1013. Therefore, we are only trying to highlight the fact that there is not even one evidence against me in this case. And also, the prosecutions have failed to establish the age of the victim. Therefore,
You have come at stage, watched the FIR or had it. But when it is
Already,
your picture is recorded. Stated everything whether
but
kind of
Lordship, as regards the maintainability of this petition, I have
Suppose there is no iota of evidence against you, then obviously
Could be no.
for acquittal.
Acquittal.
Obviously, take this for acquittal.
But
And
Lordship,
in this case, the court it cannot
Mine.
cannot conduct the
Mine.
trial.
but Lordship, there has to be some evidence against me.
No, it will considered by the court below, my lord. As the evidence already taken by the court below, my lord. My lord. My lord. My lord.
Lordship,
My lord, my lord. It is POCSO matter, my lord.
Lordship,
My lord.
on 8th, the DW, the date is fixed for DW.
Then
So
they,
please-
my lord, they statement recorded, my lord.
First of all, Lordship, this case to come under the MB to POCSO Act, the prosecution has to establish the age of the victim.
That is the concern of court below.
So my application under Section 232 has not been considered. Even I have not given opportunity to argue on that.
Against that particular order.
I have annexed.
But now it is also
No, my-
over.
I would like to refer one judgment, Your Lordship.
Whatever judgment is there, anything in the POCSO matter, as is just want to say, then we can do it. But it's not at all the case. It's not at all.
My lord.
Since the vacancy is
You
going
are
to
going
Your
to reduce
Lordship.
evidence, we consider we cannot stay also
My lord.
with the POCSO case. I'm saying we at least we can issue that.
It will linger in a case, my lord. Court
Otherwise-
below, my lord.
That's why cannot
My lord, my lord.
cannot stay. State is state. How is it DW? They are going to adduce the evidence.
My lord.
State, how can
Asking me to enter into defense, at least some evidence has to be substantiated by the
Obviously,
prosecution.
saying that there is
And
no
in,
evidence at all,
as regard,
that can be understood. That any evidence.
as far as section reverse burden is,
How court will convict? If suppose there is no at all any evidence, and even if suppose as per your submission, if suppose her age is not at the, it's okay.
if there is no evidence, then Lordship, why should I put through the lengthiness of the trial? That is the the entry prayer may be considered, Lordship.
You are Mr.
Big word. What is that?
Minor, it will also affect the minor judgment of the minor court below what the considers minor.
That is also one.
After LCR, we have received
Your DW
8 of July. Before that, it's
minor,
not
then
possible since
suppose
vacation.
we call LCR minor, it will come in the court, honorable court decided some matter. Minor, then it will have judgment.
What do you say? After detected?
Minor. It is not minor. At this stage, minor, let me reject it. After judgment, then they come to the appeal or other person minor. It's a later stage of the minor trial. It's about to minor closure minor. About to closure minor. Statement defense, thereafter minor argument. That is the matter of POXO minor.
To come under the ambit of POXO, age has to be established, but age has not been established.
Minor, it will be.
Okay,
Not by us.
okay, Lordship, I would like to...
Kindly, he is saying minor regarding age minor, page 80 minor. Page 80 medical report minor.
Medical report, but there is no X-ray report. X-ray report is also missing. That is confirmed by the MO.
It will look after by the court below minor. Minor.
So you want to should be better protected.
Minor, this is minor.
Yes. Should be detected.
Lordship, in this, I am
Again, it should be very there.
Minor.
I am referring 3 judgments on that. If Lordship pleases to...
So, can take an all report of taken of the if it's supposed for
Minor.
can copy also.
No.
In that case, we taken that report. After taking
Minor.
Otherwise, definitely DWB over.
Minor.
Obliged.
Madam, offences under my lord Wildlife Protection Act, my lord. My lord, CD may be called for my lord, and my lord immediately after vacation, my lord.
CDP call for 97 for 1 night.
Obliged.
May I please, Your Lordship? Your Lordship, 438 bail application. The FIR is at page number 13, Your Lordship. And the relevant portion is at page number 17. 17, annexure 1. Thirteen.
Minor. CD's report, minor.
Yes, Your Lordship. But Your Lordship, one more thing, Your Lordship. Here the petitioner, Your Lordship, she is the mother of the accused, Your Lordship, from whom the illegal contrabands were seized, Your Lordship. And they state totally differently. The mother, she don't have any relation with his son, Your Lordship. From the FIR itself, Your Lordship can see.
22C, 21C, minor. That is
also there.
No, Your Lordship. Actually, if I may read the FIR, Your Lordship.
at this stage, CD and FSL, minor. Minor. Minor.
Yes, Your Lordship. But The petitioner's son, he has already been arrested, Your Lordship, and he is behind the bar. And in the FIR, it is directly written that the contraventions were seized from the second floor from the room of Rahimuddin Laskar, Your Lordship.
After period of
But at least, Your Lordship, a small date, Your Lordship. Next date, Your Lordship. Short date, Your Lordship, sorry.
Short date you don't have after vacation.
After vacation.
During vacation code, Your Lordship.
Huh?
Vacation code.
No, that is.
If they don't fix it on vacation code, may make it. They are 45 days after vacation. Otherwise, where this 24/7 also methods are there. You can make it as
Okay, Your Lordship. Obliged.
filed by Mr. Kotak or Gogoi.
Petition has been filed by us. They have submitted an objection to it.
Oh, in
Division I.
We have already filed.
Yeah.
Okay.
That is your Lordship. Lordship, in filing the criminal revision, Lordship, there was a delay of 22 days. Lordship, the order of the trial court was passed on 26/2/2020, Lordship. It ought to have been filed, Lordship. We ought to have filed the revision petition within 90 days. That is on 25/5/2020, Lordship. However, Lordship, that could not be filed in time, and there is a delay of 22 days. It was filed on 16/6/2020. And Lordship, the reason for the delay is, Lordship, I have annexed in page 6, Lordship, 7, I, Lordship. Day-to-day reasons for delay in filing the criminal revision petition. Chronologically, Lordship, date has been, the reason has been explained why there is a delay. From 26/2/2020 till, Lordship, 16/6/2020. It is nothing but due to procedure in filing the revision law. We need to move to various tables, Lordship, and that is the reason why there is a delay, Lordship. Moreover, Lordship, at the time of filing the petition, Lordship, we were not intimated by the registry, and it was not kept in the defective section of the registry, filing section, Lordship. Therefore, we are not aware of it, Lordship. And when the matter was also moved, the respondent then never raised any objection with regard to the delay. Only on the page end of argument, Lordship, they have raised this point, Lordship, that there is a defect, if there is a delay in filing the revision petition, therefore on that ground, Lordship, the petition could be dismissed. I have also placed one judgment earlier, Lordship, regarding the filing of the revision petition, Lordship. There's 2021 7 SCC 313, Lordship, where it has been held, Lordship, by the Honorable Apex Court, Lordship. Filing of application seeking 2021 7 SCC. I have already placed on record, Lordship.
Oh, maybe.
I have placed it, Lordship. 2021 7 SCC 313 SCC online. I have placed it on record on the last occasion. It was held, Lordship, that filing of application seeking condonation of delay under, it is not mandatory to file an application in writing before relief can be granted under Section 5 of Limitation Act. Further, no applicant or appellant can claim condonation of delay under Section 5 of the Limitation as a right without making an evidence. So, Lordship, it is completely the discretion of this Honorable Court whether delay is to be condoned or not, Lordship. That is the thing, Lordship. And formal application is not required, Lordship. However, Lordship, we have filed subsequently when we have came to know about it, Lordship. Formally, we have filed the application seeking condonation of delay under Section 5 of the Limitation Act. That apart, Lordship, I am placing one more judgment, that is State of Rajasthan versus Banwari Lal. What they want to say is that there is not 22 delays,
it is more than 22, that is 1,000 something days, Lordship. Our submission, they are saying, Lordship, they are filing an objection whereby they want to say that at the time of filing, it should have been filed by us. But as because we have not filed, so delay will count till the date of filing of the present IS. That is their stand, Lordship. But as because they have not pointed out this point, and that has not come to our knowledge also, Lordship, therefore the count should not be considered, Lordship. And moreover, even if we, Lordship, Lordship, I want to, based on judgment of Honorable Apex Court, State of Rajasthan versus Banwari Lal, Lordship, where, Lordship, in para 8, page 7, there is a delay in filing the appeal by the state, Lordship. 1,880 days delay, Lordship. That has been condoned by the Honorable Apex Court. It was held in para 8, Lordship. So I am placing this judgment also, Lordship. So considering the gravity of the offence, Lordship, I have prayed before this Honorable Court to kindly condone the delay of 22 days in filing the revision petition, Lordship. That's my humble submission.
Lordship, our case is this, Your Lordship, this petition, Your Lordship, this IA is not maintainable at all, Your Lordship. The registry could not have even, Your Lordship, take note of this IA, Your Lordship, and registered a case on the basis of that application, Your Lordship. That they could not have done, Your Lordship. That's the case, Your Lordship. Now, Your Lordship, at B stage, Your Lordship, our objection, Your Lordship. Your Lordship may kindly take up the limitation at first. Lordship, so far as the high is concerned. Lordship, that can be taken. Section 3 of the limitation. Subject to the provisions contained in section 4 to 24, inclusive every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed, although limitation has not been set up as a defense. Even if we don't set it up as a defense, Your Lordship, it will have to be dismissed. It cannot be, Your Lordship, proceeded with it. That's whether we take, Your Lordship, set up a defense on the point of limitation is not material, Your Lordship. What is material, Your Lordship? That the court cannot proceed with this, Your Lordship. And in the entire application, Your Lordship, of the revision petition, Your Lordship will find there is not a single prayer, Your Lordship, single statement explaining the delay, Your Lordship. If that is not there, Your Lordship, court cannot even take note of that, Your Lordship. The question of condoning delay will come when, Your Lordship, without application, when they make such prayer in the main petition, Your Lordship. That they have not made, Your Lordship. The issue before this Honorable Court is not that, Your Lordship, whether a separate application will have to be filed or not. Your Lordship. That is not our case. In the main petition, criminal revision petition, they have not made any prayer for condoning the delay, Your Lordship. In absence of that, whether this honorable court can condone the delay, Your Lordship. That's number one. And number two, Your Lordship, is at a belated stage, Your Lordship. What is the purpose of filing this IA, Your Lordship? The IA is filed, Your Lordship, only on condoning the delay. Once delay is condoned, then the main petition is, Your Lordship, numbered, registered, Your Lordship. Till then, Your Lordship. So therefore, Your Lordship, this IA is not maintainable in the present form, Your Lordship. That's our case, Your Lordship. At belated stage, by bringing an interlocutory application saying now this honorable court is required to condone the delay, that cannot be done, Your Lordship. Therefore, Your Lordship, both these petitions, Your Lordship, main criminal revision petition as well as the IA is liable to be dismissed on that ground alone, Your Lordship, on the ground of maintainability, Your Lordship, whether we set the point of limitation as a defense or not, Your Lordship. That's the Honorable Apex Court has settled that position, Your Lordship. I will show even Constitution bench of the Honorable Court way back in 1964 has settled this law, Your Lordship. And this judgment, Your Lordship, which my learned friend is relying upon, it's completely on a different facts, Your Lordship. This has nothing to do with what the present case involves, Your Lordship. So, Your Lordship, Section 3, Your Lordship, has gone to Your Lordship, and for that, Your Lordship, Section 5, Your Lordship, if we read Section 3 and Section 5, Your Lordship will kindly come to Section 5. And any appeal or any application other than an application under any of the provisions of Order 41 of the Code of Civil Procedure may be admitted after the prescribed period of appeal, and an applicant satisfies the court that he has sufficient cause for not preferring the appeal and making the application within such period, Your Lordship. That must be there, Your Lordship. Even if it is not talking about, Your Lordship, and separate application, in the main application it will have to be there. Unless it is there, how can this Honorable Court may condone that, Your Lordship? This Honorable Court cannot, Your Lordship. And then filing an interlocutory application under Section 5, Your Lordship, by that, that's a contradictory stand, Your Lordship. By filing the separate application, they themselves admitted that separate application is required. On the one hand, they are saying that no separate application is required based on a judgment passed by the Honorable Apex Court. On the other hand, they are, Your Lordship, themselves is filing an interlocutory application, Your Lordship, a separate application for condoning the delay. That itself is contradictory, Your Lordship. And that is also a ground on which this IA is liable to be dismissed, Your Lordship. Their contention is liable to be dismissed, Your Lordship. Now, Your Lordship will kindly see this judgment my friend has relying upon, Your Lordship. 2021 7 SSC 313. If Your Lordship takes up that judgment, Your Lordship will find Para 19, Your Lordship, kindly come. NCLAT examined the issue of limitation and held that the respondent had bona fide within the period of limitation initiated proceeding against the corporate debtor under SARFAESI Act and was thus entitled to exclusion of time under Section 14(2) of the Limitation Act. This is precisely the issue, Your Lordship. Under 14(2), Your Lordship, of the Limitation Act, they are seeking exemption, Your Lordship. Now, Your Lordship will kindly come to para where the issue of this para 55. Para 51, Your Lordship, may kindly take up first, Your Lordship. Para 51. Section 5 of the Limitation Act provides that any appeal or any application other than application under any of the provisions of Order 21 Code of Civil Procedure 1908 may be admitted after the prescribed period of limitation if the appellant or the applicant satisfy the court that he had sufficient cause for not preferring the appeal or making the application within such period. The explanation in Section 5 of Limitation Act clarifies that in fact that the appellant or applicant may have been misled by any order, practice, judgment of the High Court in ascertaining the computing the prescribed period may be sufficient cause within the meaning of this section, Your Lordship. Then, Your Lordship, 55. The issue involved in this appeal are whether delay beyond 3 years in filing application under section 7 of IBC, Your Lordship, can be condoned in the absence of an application for condonation of delay made by applicant under section 5 of the Limitation Act 1963. If you are relatable to the, Your Lordship, this IBC, Your Lordship. Now, Your Lordship will kindly come to page para 59. The condonation precedent for condonation of the delay in filing an application for appeal is the existence of sufficient cause. Whether the explanation furnished for the delay would constitute sufficient cause or not would be depend upon the facts of each case. There cannot be any straitjacket formula for accepting and rejecting the explanation furnished by the appellant applicant the delay in taking step. Acceptance or explanation furnished should be the rule, and refusal action when no negligence in action 1 to bona fide can be imputed defaulting party. Then para 61, Your Lordship, which, Your Lordship, section 5 of the Limitation Act does not speak of any application. The select section enables the court to admit an application or appeal if the applicant or appellant, as the case may be, satisfied the court that he had sufficient cause for not making the application and or preferring the appeal within the time prescribed. Although it is general practice to make a formal application under section 5 of the Limitation Act 1963, in order to enable the court or tribunal to weigh the sufficiency of the cause or the inability of the appellant applicant to approach the court tribunal within the time prescribed by the limitation, there is no bar to exercise the court tribunal of its discretion to condone delay in the absence of a formal application. Formal application may not be required, Your Lord, but their statement in the main petition will have to be there. That's what this judgment says, Your Lordship. It not says that there should not be any explanation at all. Court on its own motion can condone the delay. That is not the case, Your Lordship, here. So, Your Lordship, even assuming that this is somehow applicable, even then, Your Lordship, they will have to make the explanation in the petition itself, Your Lordship. Then 62, Your Lordship, a plain reading of section 5 of the Limitation Act makes it amply clear that it is not mandatory to file an application in writing before relief can be granted under the said section. Had such an application been mandatory, section 5 of the Limitation Act would have expressly provided, so the section 5 would then have read the court might condone the delay beyond the time prescribed by limitation for filing an application or appeal if on consideration of the application or the appellant or the applicant, as the case may be, for condonation of delay, the court is satisfied that the appellant applicant had sufficient cause for not preparing an appeal or making the application within such period. Alternatively, a proviso for explanation would have been added, section 5, requiring the appellant or the applicant, as the case may be, to make such application for condonation of delay. However, the court can always insist that an application or affidavit showing cause for the delay be filed. The no application or appellant can claim condonation of delay under section 5 of the Limitation Act as a right without making any application, Your Lordship. That is also there, Your Lordship. Matter of right one cannot claim, Your Lordship. Now, Your Lordship will kindly note, Your Lordship, this judgment will have to be read with the, Your Lordship, judgment earlier passed by the Honorable Apex Court, Your Lordship. Even in a recent case, the Honorable Apex Court has held that even if we don't set up the limitation as a defense, Your Lordship, even then the court cannot proceed with the case. Your Lordship will kindly take up this judgment, Your Lordship. First, Your Lordship, this is, Your Lordship, 2005 4 SSC 613 December. Para 19, Your Lordship. Your Lordship, the judgment my friend is relying on is a quorum of 2 judges, Your Lordship. This is also by a quorum of 2 judges, Your Lordship. Para 19. Para 19 quotes the section, Your Lordship. Then para 20 and 21, Your Lordship. The mandate of section 3 of the Limitation Act is that it is the duty of the court to dismiss any suit instituted after the prescribed period of limitation, irrespective of the fact that limitation has not been set up as a defense. If a suit is expressly barred by the law of limitation, a court has no choice but to dismiss the same even if the defendant intentionally has not raised the plea of limitation. Then your lordship, this is the next paragraph. In this court in so and so versus so and so, this is your lordship, three judge bench, the quorum of three judge bench, your lordship. Section 3 of the Limitation Act enjoins the court to dismiss any suit instituted, appeal preferred, application made after the period of limitation prescribed, therefore by Schedule 1, irrespective of the fact whether the opponent had set up the plea of limitation or not. It is the duty of the court not to proceed with the application if it is made beyond the period of limitation prescribed. The court had no choice, and if in construing the necessary provision of the Limitation Act or in determining which provision of the Limitation Act applies, the subordinate court comes to an erroneous conclusion, it is often to the court in revision interfere with that conclusion. The conclusion led the court to assume is not required. Now, your lordship, this three judge bench as well, as that this on the count of limitation, your lordship, the court cannot proceed with the petition, your lordship. Now, your lordship will get the judgment of three judge bench, your lordship. Good, go ahead. Your lordship, this is by, that has been relied on, your lordship, para 9, your lordship, of that judgment. Now, your lordship, even very recently, your lordship, in 2024, this is not reportable judgment since law has already been settled, your lordship. Therefore, it's not reportable, your lordship, non-reportable, your lordship. Para 15, your lordship. Relying on the, your lordship, VM Salgaonkar, which I have already handed over to your lordship, para 15, your lordship. I will not read it again, your lordship. The Honorable Apex Court has reiterated the same law, your lordship. Thus, it is a para 16, thus it is a settled law that even if the plea of limitation is not set up as a defense, the court has to dismiss the suit if it is barred by limitation, your lordship. These are, your lordship, settled law, your lordship. Now, your lordship, the law laid down by a quorum of three judge bench, your lordship, of the Honorable Apex Court is, your lordship, binding on all other benches, your lordship. If it goes against, and if we accept their contention so far as this particular judgment is concerned, your lordship, that your lordship will have to see in the context of, your lordship, this 1964 judgment, your lordship, which has relied on again and again by the Honorable Apex Court by a quorum of three judge bench, your lordship. And what will be the principle, what principle is required to be followed in such circumstances, your lordship? That has also been, your lordship, discussed by Honorable Apex Court in judgment, your lordship. That is, your lordship, official liquidator versus Dayanand and Abdayaram and others, your lordship. Your lordship may kindly peruse the para 78, your lord, of this judgment. Para 70. There have been several instances of different benches of the High Courts not following the judgments orders of coordinate or even larger benches. In some cases, High Courts have gone to the extent of ignoring the law laid down by this court without any tangible reason. Then, your lordship, likewise, there have been instances in which smaller benches of this court have either ignored or bypassed the ratio of the judgments of the larger benches, including the constitution benches. These cases are illustrative of non-adherence to the rule of judicial discipline, which is sine qua non for sustaining the system. In so-and-so versus so-and-so, this court observed, if one thing is more necessary in law than any other thing, it is the quality of certainty. That quality would totally disappear if judges of coordinate jurisdiction in a high court start overruling one another decisions. If one division bench of a high court is unable to distinguish a previous decision of another division bench, and holding the view that the earlier decision is wrong itself gives effect to the view that the result could lead to others utter such confusion. The position would be equally bad whereas judge sitting singly in a high court is of the opinion that previous decision of another single judge on the question of law is wrong and gives effect to that view instead of referring to the matter to a larger bench. In such a case, lawyers would not know how to advise their clients, and all courts subordinate to the High Court and would find themselves in an embarrassing position of having to choose between dissenting and judgments of their own High Court. Then, Your Lordship, different judgments are referred to. Then, para 84, Your Lordship, may kindly come. In State of Bihar versus Kalika Queer, the court elaborately considered the principle of par incuriam and held that the earlier judgment by a larger bench cannot be ignored by invoking the principle of par incuriam, and the only course open for the coordinate bench or smaller benches is to make request for reference to the larger bench, Your Lordship. Then, Your Lordship, para 90, Your Lordship. We are distressed to note that despite several pronouncements on the subject, there is substantial increase in the number of cases involving violation of the basic judicial discipline. The learned single judges of benches of the High Court refused to follow the accept the verdict and law laid down by coordinate even larger benches by citing minor differences in the facts on the ground for doing so. Therefore, it has become necessary in the facts on the ground for doing so. Therefore, it has become necessary to reiterate the disrespect to the constitutional ethos and breach of discipline has given impact on the credibility of judicial institutions, encourages and chance litigation. It must be remembered that the predictability and certainty is an important hallmark of judicial jurisprudence and developed in this country in the last 6 decades. An increase in the frequency of the conflicting judgments of the superior judiciary will do incalculable harm to the system, inasmuch as the courts are at the grassroots will not be able to decide as to which of the judgments lay down the correct law and which one should not be followed. Now, Your Lordship, in a case of this nature, Your Lordship, when this law is settled and this in this particular case, Your Lordship, official liquidator versus Diana, Your Lordship, Honorable Apex Court has very clearly said that this tendency, Your Lordship, to contradict the larger bench judgment by smaller benches, Your Lordship, this could not be, and therefore, Your Lordship, this judgment is not applicable so far as this judgment, Your Lordship, law laid down in this particular judgment relied on by my friend, Your Lordship, cannot be, Your Lordship, relied upon, Your Lordship. Because, Your Lordship, it is directly contradictory to what the Honorable Apex Court, the larger bench of Honorable Apex Court has already laid down, Your Lordship. Therefore, Your Lordship, this judgment, in my humble submissions, cannot be taken note of, Your Lordship. And one more judgment, Your Lordship. It will be the 2022 SSC Online, para 28, Your Lordship. Para 28. The conclusion one is that the decision delivered by a bench of largest strength is binding on any subsequent bench or lesser or co-equal strength. It is the strength of the bench and not the number of judges who have taken a particular view which is said to be relevant. However, conclusion to make it absolutely clear that a bench of lesser quorum cannot disagree or dissent from the view of law taken by the bench of a larger quorum. Quorum means the bench strength which is hearing the matter, Your Lordship. So, Your Lordship, this judgment, Your Lordship, even if, Your Lordship, they have relied on, and Your Lordship will kindly note, Your Lordship, in this particular judgment relied on by my friend, Your Lordship, the earlier larger bench judgments have not been considered, Your Lordship. Without considering those law, Your Lordship, laid down by the Honorable Apex Court, Your Lordship, this judgment has passed, Your Lordship. Therefore, Your Lordship, this judgment cannot be relied on, Your Lordship, in my humble submission. And this is my submission so far as this delay point is concerned. And two judgments, Your Lordship, I will not argue on that, Your Lordship, only submit 2 copies, Your Lordship. This is on the merit of the case, Your Lordship. That is, Lordship? Lordship. That is one, Your Lordship. This is very recent judgment of the High Court, Your Lordship, of Karnataka, Your Lordship. Page 37, Your Lordship. Read it. This is on the point of Your Lordship. This the here, Your Lordship, the order of Your Lordship directing for telephone tapping, Your Lordship, was, Your Lordship, is an issue, Your Lordship, and the Karnataka High Court, Your Lordship, it starts from the relevant starts from Your Lordship. Your Lordship will page 18, para 12, Your Lordship. I will not read it, Your Lordship. I am only Your Lordship. Para 12, Your Lordship. Para 12 onwards, Your Lordship, and Your Lordship, finding, Your Lordship, will get at page 37, Your Lordship. Page 37, Your Lordship. Yeah. And secondly, Your Lordship, another judgment, Your Lordship, it's very recent, on section 5.1 of the Indian Telegraph Act, Your Lordship. Under what circumstances in order under section 5.1 can be passed, Your Lordship. This is 2023 SCC 637, Your Lordship. Anuradha Bhasin, Your Lordship, versus Union of India. Here, Your Lordship, will get the relevant paragraph, Your Lordship. Your Lordship will get, Your Lordship, para 98 onwards. Para 98, 99, 100 and 101. More specifically, Your Lordship, 101, Your Lordship, where the true connotations of, Your Lordship, the public emergency has been, Your Lordship, discussed, Your Lordship. And if Your Lordship permits, Your Lordship, by tomorrow we will file a written submission, Your Lordship, by tomorrow. Deeply obliged.
We have some fail matters, in fact, so I don't know what if any. We want to submit it just for 10 minutes or 5 minutes.
My learned seniors, I could have blank, my lord, many issues have been pointed out. My lord, I would like just to point out, my lord, the concluding paragraph of the judgment of Sheshnath. It is applicable, my lord, but in a reverse way. Concluding paragraph. The Sheshnath judgment, my lord, where it says, well, without application one can come. Concluding paragraph, my lord, first, my lord, the entire genesis of this judgment is, my lord, because, my lord,
and now the
yes.
Mr. Bhattakur
Yes.
is already stressed on the para 1950.
No, I am coming directly to the concluding paragraph, my lord. It's paragraph 102 in my the printout I am holding, my lord.
102.
102. Maybe different, my lord, because that is SCC, this is Manupatra.
Should have 102. Anyway.
Well, I am giving this one.
Okay.
Well, entire case, this case, because in this Insolvency Act, Limitation Act is not applicable strictly. 102 is there, last page.
Okay.
So,
Here
Lord,
it is
that
100 and
paragraph-
101.
Yes, yes.
Your
It's 102.
102 and 103, yes, 100 and 100. Okay.
Well, that says, my lord, it says it can, at cost of repetition, it is in any case, Section 5 and Section 14 of Limitation Act are not mutually exclusive. Even in a case where Section 14 doesn't strictly apply, the principle of Section 14 can be invoked to grant relief to an applicant under Section 5 of the Limitation Act by purposively construing sufficient cause. It is well settled that omission to refer to a correct section of a statute does not vitiate an order. At the cost of repetition, it is reiterated that delay can be condoned irrespective of whether there is a formal application or not, if there are sufficient materials on record disclosing the sufficient cause of delay. My lords, leaving this IA aside, my lord, that argument has to flow from the facts of the case and the averments made in the petition, my lords. In this case, my lord, there is no statement why is delay, my lord, and this delay is not now of not 22 days. After only I pointed out, my lords, recall, my lords, I pointed out they wake up from a deep slumber, they come with this, my lords. And apart from that, my lord, this judgment is wholly, my lord, to the facts of the case that it is because this is, my lord, Lordship see this IBC code is involved there, my lord. Wherein, my lord, it has been stated in its statute that Limitation Act is not applicable. Maybe so it has been used as far as maybe, my lord, not strictly applicable. That is my humble submission, my lord. Other issues, my lord, if I fail at this stage, then other arguments I will make in that. If somehow if that.
What other?
Oh, then I'm not on the other merits of that other order, my lord.
You may file. Have you filed your written?
No, my lord. I have.
You are at liberty. You can file. Mr. Botapur is also going to file.
Yes, ma'am. Perhaps he files first. I can take a cue from him. Okay.
My lord, I just want to make a reply, Lordship. My lord, I just want to make a reply. The only thing is that whether there is sufficient cause or not, on record or not. We have brought on record now the sufficient cause. That is my reply.
Okay.
Deeply obliged.
May it please your Lordship.
Is it 44?
Lordship, these are two interlocutory applications, my lord. 43 and 44. My lord, same identical prayer by the bail petitioner. These are bail petitions which are disposed of, my lord, allowing the petitioner's bail back in the year 2021 itself, my lord. So, my lord, may take up the item number 43 first, page number 10, my lord. That is the bail order of the applicant, one Mr. Pankaj Kakoti, my lord. Here's your lordship. My lord, Pankaj Kakoti, this order, my lord, was passed on 7/10/2021, my lord. So this is a case, my lord, where the NDPS Act is also there, my lord. A small quantity. However, these petitioners, my lord, they came into the picture because at that time the COVID rules were being implemented, my lord. And they were attending a birthday party, so that is why they were also in the condition. While enlarging them on bail, my lord, at page number 14, my lord. Page number 14, point number 11. Paragraph 11. Page number 14, point number 11. These are the conditions of bail, my lord. Here, my lord, at point number B, shall deposit, 11B, my lord, I am reading, shall deposit his passport, visa, etc., if any, in the court of the learned jurisdictional special judge. So only this condition, my lord, that my passport needs to be returned to me. There are some purposes, my lord, I need to renew it. And my lord, I have an upcoming business trip, my lord, for which, my lord, the invitation is also annexed, my lord. And prior to that, my lord, I would beg to state that the prime accused person in whose house the instant get-together was taking place, his passport has already been returned by this honorable court, my lord. That is at page number, my lord, 17, my lord, Vikas Jain. Already more than a year back, his passport was returned, and subsequent to his passport return, my lord, another 5-6 accused persons' passports have been returned, my lord. And my lord, the learned prosecution has also very fairly submitted in those other matters, because merely returning the passport does not enable me to travel abroad, my lord. In all the bail prayers, there is another condition that prior to going abroad, I need to take permission from the special trial court. And I am not seeking revocation of that condition, my lord. Only my passport, so because applying and all, my lord, that takes a lot of time, my lord. So that, and subsequent to, my lord, permission by the trial court, only then I am allowed to travel. And that is my sole limited prayer, my lord. That 11B, my lord, that may be revoked. 11A, let it be there. I'll seek permission from the honorable trial court and then move abroad, my lord. That is all, my lord. And my lord, the other similarly placed accused persons orders I have annexed, my lord. At page number 17, one order is there. At page number 19, another order is there, my lord. And my lord, page number 22, another order is there. Similarly placed accused persons, my lord. Only the passport is returned. By taking due permission from the learned trial court, they may move abroad and come back and report again to the trial court, my lord. Same with, my lord, item number 44, subject to what my learned friend has to say.
My lord, through that action, my lord, he is only, my lord, seeking relaxation of the, my lord, 11B, my lord.
11B,
regarding A, my lord, he will take prior permission when he will go, my lord.
Yes, my lord.
Outside of the, my lord, judicial court. That 11A, my lord, that will be removed. That 11A will remain, my lord. He will take prior permission from the court.
Praying for revocation of 11B only.
11B, yes, my lord.
So that the passport can be returned
that, my lord.
for the other.
That for applying and everything, that process, and subject to the permission of the trial court only, I may go abroad. Only difference in item number 44, my lord, is that there it is 11B, my lord. Here it is paragraph number 17B, my lord. Otherwise, it's same, my lord. Contents are same. In item number 44, my lord, it is 17B. And in item number 43, my lord, it is 11B. The revocation which I am seeking. That's all, my lord. That's all, my lord. I am deeply obliged, my lord, and thankful to my learned friend as well, my lord, for being fair. Deeply obliged, my lord. Disposed of.
May I please understand? Earlier the scan copy was called for, my lord. Record is there.
I have produced the scan copy, my lord. It is very initial stage, my lord. As last order was, my lord, 13/6/2024. And as per order dated 13/6/2024, the case is fixed on 27/6, tomorrow morning, for consideration of search.
Hereafter, as per charge, my lord, my name is not there, I think. And my lord, nothing has been submitted.
No, charge is submitted against two persons, my lord. Shahrukh Khan and Ikramul Ali, my lord. He is Ikramul Ali.
I am Ikramul Ali.
So against him,
Charge is there.
That's why
But
you are not charged.
No, my lord. Sorry, my lord. Paragraph 10, your lordship.
Huh?
In the charge sheet, paragraph 10.
Paragraph 10.
Yes, my lord. Yes, my lord. I have seen the record. I think final report, your lord. And nothing has been recovered from my possession and also from my phone.
Final report.
Yes, my lord.
Final report is submitted, my lord. Submitted, my lord.
Yes, my lord.
Charge is submitted against both the accused persons, my lord. There are two accused persons, my lord. He is representing Ikramul Ali.
For the consideration of charge.
My lord. 27/6. That is my lord, day after tomorrow.
On the basis of the statement of the accused Shahrukh Khan, your lordship, I am arrested from my home, your lordship. And nothing has been recovered from my possession and also from my home, your lordship. Only on the basis of the statement of the Shahrukh Khan. And already I have behind the bar, your lordship, 149 days today, your lordship. So on the consideration of length of detention, I may be allowed to go on bail.
Progressing case is also progressing. That part, they have got tomorrow for consideration of charges.
Lordship, I'll fix it, my lord, after reopening, my lord. In the meantime, after the report may be called for whether, my lord, charges time
Or
or
at least you can file your petition for discharge also. Suppose using all those grounds, you can file your petition for discharge. But the state not. So they need to status report called.
status report be called for, and my lord, on 27, my lord, they can file discharge also.
Yes.
Yes, lord. The trial period will consider.
I may assist them, your lordship.
Yes.
Ready. Oh, very good.
As the you have 15 it on 24/7, otherwise of commercial economy and case is progressing in fact. But yes, obviously, if you do not, if there is nothing against you,
Yes, ma'am.
that may be one of the reasons for your bail or discharge also. So you can pray for discharge, we are calling it the status report on 24/7.
24/7.
Calling praise
Status report 24/7 after petition.
after.
But then I may be allowed to on 27, I may be clear for discharge and trial.
That
And
time
trial
I
court.
made an occupancy order. Take a name for some food that is made for prayer. Certainly not that is all of that. But you make an observation that you may make a prayer before the runner court for you. That is I have also. Observation is already made that you have submitted that there is no evidence against you.
Yes,
Only
ma'am.
on the basis of the co-accused statement of the that you were arrested. If so, they make the prayer before the runner court on the day of charge. That considered of our but we can find. You may make a prayer before the runner court for your decision. We have already reflected in our order. Otherwise, we are fixing it up to court.
Must oblige, sir.
My lord, in this case, my lord, the petitioner is behind the bar from the last, my lord, 78 days. From the last 78 days, he is behind the bar. FIR, my lord.
In this case, I shall appear for the informant. They have instructed me to appear, but I am going to file my color today. Matter will be taken up tomorrow, Lordship.
In the meantime, he will file, my lord, your lordship, pass order. Because 78 days. In the meantime, lordship.
We have here him.
I cannot.
Yes.
How
Tomorrow, my lord,
then.
No, he is saying filing about Okalatnama.
It's sort of accommodation, Lordship.
Tomorrow.
Okay.
May please, Your Lordship.
Thank you.
439 application, my lord. Petitioner is behind the bar for today's 32 days. Invoked under 21B of NDPS Act, but the suspected heroin recovered from a car, 4.18 gram, my lord, which is a small quantity. It should.
Case that is not received today, my lord.
Case 20, my lord, the order of the learned magistrate for sampling the suspected drugs, my lord. The relevant person has case 22 recovered the entire suspected drugs was weighted and it was found 4.18 gram. And it was not recovered from the possession of the present petitioner. It was recovered from a car, my lord. The petitioner was in the car. The driver is the friend of the present petitioner, while the police apprehended.
Okay, not from your conscious person.
Lordship.
Obviously, it is less than 5 grams. So it may come under the 25, A, small one.
Case that will be required immediately after detention, my lord.
Lordship, 32 days considering the period of detention.
My lord, 15, my lord. 15. Otherwise, Lordship can fix it, my lord, on the last day, my lord.
Say that if you read that
28.
28,
28 is the last day, my lord.
last day, okay.
All right.
Remind. It should remind.
My lord.
Yes. 28.6.
No, item number 19 and 29 may be taken up together.
19
29 and 29, my lord.
So, for 39 application, Lordship, I am behind the bar for 33 days, Lordship.
29 or 20. 29.
So 29 is AB.
AB and 19 is
19 is BA.
BA. I am behind the bar for 33 days. Case was registered under section 420 and 1314 of Assam Game and Betting Act. Allegation is that some materials related to gambling was recovered from my possession and cash was also recovered. I have a shop, Lordship, and cash was recovered from my case box. Already 33 days, Lordship, considering my period of detention, Lordship.
Why 420 is also there?
Lordship, 13 and 14 is there.
13 and 14 is there along with 420.
420, with all respect, Lordship, may not be applicable in these circumstances because there is no inducement or deceiveness. Nobody has come forward that saying that I have been deceived and on being deceived I have purchased the ticket for gambling. There is no such. Most probably the city also will not reveal that anybody has come forward and saying that on being deceived I have purchased ticket from so and so. Only thing is the informant is itself a police officer, ASI. He lost an affair saying that I used to sell tickets to an innocent person. Those innocent person has to come forward and say or lose an affair that on being induced I have purchased the ticket. That is absolutely not there. Okay. And considering the period of detention, 33 days conviction sentence, which may start from 6 months, which may extend to 3 years. Already 33 days, considering the period of detention, okay. There is almost investigation is almost complete because they have recovered allegedly they have recovered the materials for betting.
Well, we have received the case that the investigating officer they have collected sufficient materials, my lord, against all the three accused persons, my lord. And this accused person, my lord, these two they were present, all the three were present, my lord. But my lord, item number 29, my lord, Vipul Odhikari, he fled away from the spot, my lord. That is why my lord, police is searching him, and my lord, from their position, my lord, from the arrested accused person, my lord, some my lord calculation sheet, wherein my lord is gambling, my lord, it was noted, my lord, in the calculation sheet, and my lord, gambling circular sheet, my lord, that has been, my lord, seized, along with money, my lord, cash money, my lord. So, my lord, it is pending for further investigation and, my lord, to apprehend this accused person, my lord, Vipul Adhikari. All three are, my lord, connected, my lord, they are associated. My lord, witnesses, several statements, several person statements has been recorded, my lord, all have implicated them, my lord. And they are, my lord, polluting the area, my lord. Nearby. They were asked, my lord, not to, my lord, to, my lord, do, my lord, gambling business, my lord, but they have not cleared them. And, my lord, they are continuing their business, my lord, for, my lord, easy money, easy digital money.
Though whether articles recovered were actually used for the gambling or not.
It was recovered from the place of occurrence, my lord. Police apprehended two persons from their position. These were recovered along with cash money, and another person, my lord, item number 29, he fled away.
Pawn shop, Lordship, and money was recovered from the cash box. It is related to the business, pawn shop business. 33 days, Lordship. Whether there is any requirement of custodial interrogation.
Investigation is pending, my lord, because this accused person is yet to be arrested, my lord.
There are
Regarding item number 19, Lordship, if Lordship consider, my lord, that I leave it to Lordship, my lord. But regarding item number 29, my lord, he is yet to be interrogated, my lord. He is apprehending arrest, my lord. And police is searching him. And that is why investigation is pending.
Regarding
420, my lord, they asked, my lord, people, my lord, to play gambling, my lord. That is
That
they
is
said that if you invest 10 rupees, you will get 10,000 rupees.
There has to be an allegation from that for those
That is
persons.
investigation is there, my lord. Tomorrow, my lord, 420 may not be there, my lord. While everything
Lord PP is absolutely fair. 420 will most probably, with all respect, Lordship, will not be applicable in this case. And so far, 13 and 14, imprisonment for 6 months. Already I am 33 days, Lordship.
who has the punch? One, number one.
Lordship.
Pancho, who is having punch?
Both of them are. 439 are applicable because দুজনে both 439 দুজনে grocery shop মানে আছে.
Paragraph 8.
So both the petitioners are having punch shop.
One is having transport and another is having a grocery shop. Accused number 1.
Yes. Now, you know, it's pending for, I mean,
Bangladesh.
How come?
So far as the 29 AB is concerned, Lord,
What do you want to say?
as far as AB is concerned, as per the statement of one of the accused, he was implicated in this case. Or otherwise, as it appears from the FIR, he was just a collecting agent. He was an employee of these two persons who were arrested. Nothing has been recovered, nor he was found present in the place of occurrence. On the basis of statement only, and he was an employee of these two persons, as per FIR. So custodial interrogation, with all respect, may not be necessary because of the section 13 and 14 will not be attracted against this person because he was not found in vetting of anything. He was just, as per FIR, he was a collecting agent, just an employee of that two persons who were already arrested, and Lordship was pleased to grant them bail. So considering that, Lordship may consider the bail application.
So 29 is rejected. 18 is allowed, 29.
Give you.
So here now, 20, you have
My Lord,
that
CD is called with effect from October 2023, my Lord. 23. October 2023. CD is waiting for that.
are you on entry?
My Lord,
You're in.
unless, no, not interim, my Lord. The interim is not granted, my Lord. I think, my Lord, interim is not granted, my Lord. They will not
NIA, my Lord.
Oh.
NIA name is shown.
NIA,
Their name has been shown, my Lord. NIA advocate has been shown in the cause list, my Lord.
No, they have appeared. The case is already transferred to NIA.
My Lord.
But I don't know who is the pending counsel for the counsel for the NIA. Mr. Das or
Okay, Mr. Das, my
huh? Mr. D. Das.
D. Das. Dilip Das.
Dilip Das.
Dilip Kumar.
Can be informed?
His name has been found, my Lord.
Okay. Try to inform him.
My Lord. At 2 1.
Because they may not be in a position to say as to the
My Lord.
লোকালি আঙ্গুল কাটা এটা করতে এটা আপিল যে লোকালি আসতে যে আপিল এই এই যে বলে বলে কাটে বলে না হাত দে বুঝতে পারে
causes also name is reflected in that. In the cause list also, the name has been reflected.
Reflected, my Lord.
For the standing council of the
Yes, my Lord.
Now,
My Lord, this is not the first time, my Lord. Earlier, two dates also, their name is shown. And this case is pending since October 2023, my Lord. My Lord,
do you have any idea who is actually conducting the as per the cause? The dance is conducted.
My Lord, he is requested by the display board also.
Otherwise, investigated by NIA, in fact. It has already been most probably handed over to. So, the case is registered under 150p, 121A is also there. Apart from 419, 468, 471, and then apart the UP Act is also there. We have to hear the No, it's not there now.
It's still there. Unit.
Oh, it's still there.
My lord, may I pay for my grant of interim, my lord? The matter is pending in October 2.
Interim cannot take that. Here. Otherwise, we have not received any report at all.
Before vacation, one attempt, my lord.
No, how can? How can?
My lord, the matter is pending October 2023, my lord.
Yes, I have seen from October. From the record dedicate the pending since October 2024 and on 7th the order has been passed for qualification certificate or put a from there. Further from the orders was by the court that the LCPS has now transferred via the name of one Mr. D. Das, the standing counsel of NI. The NI is court. However, no one has represented on the side. On the side. Article 1 done is the DFP as it is taken up by so it did as it did the name of the Assam or the of the Assam from the court. Yes. Further that inform that not as that of remind as that becomes can we did this. No, not this one. After this. Wait, see, we are 2027. And directly, we have already directed the registry to inform Mr. Dan, who is the standing counsel of me. Otherwise, they are also trying, their board is also there, but it's not responding. See? Otherwise, David will be open, not the later of the open. Without hearing the other side, including that is the thing. So we'll listing it on 22nd of July?
July.
Yes. By that time.
Lovely.
May it please your lordship.
Lordship, this is a 438 bail application, Lordship. We have the FIR, Lordship, will find on page 13, Lordship. Page 13, Lordship, specific allegation against two persons, Lordship, recovered from that two person is Ajit Pal and Satish Burman, Lordship. 820 gram of methamphetamine tablet recovered from them, Lordship. Thereafter, Lordship, this was on 3/8/2023, Lordship. Thereafter, the statement of this two arrested accused person has been recorded under 67C, Lordship, of the NDPS Act, Lordship. Their, Lordship, accused number 1 stated, Lordship, in page 17, Lordship. It starts from page 15, but in page 17, Lordship. Question number 2. This petitioner name first appeared, Lordship. For trafficking of the said methamphetamine tablet, I had to get 30,000 cash from Mohammad Malik after delivery to him. That was not received, Lordship. Thereafter, Lordship, that Satish Burman, he has not stated anything against this petitioner, Lordship. After that, Lordship, notice was sent to this petitioner, Lordship, under 67C. That is on page 29, Lordship. Can you see the date of the notice? And the Lordship, he has been asked to appear before the NCB, Lordship, on 12/1/2024, Lordship. Page 29, Lordship.
Yes. Yes.
Then, Lordship, what happened? The charge sheet, Lordship, has been submitted against, Lordship, Ajit Pal and Satish Burman, not against this present petitioner, Lordship. The offence report will find in the order LCR, Lordship, on 29/1/24, Lordship. Cognizance has been taken against those two persons, not against this petitioner, Lordship. Now, at this stage, Lordship, LCR, Lordship, 29/1/24's order reflect that. Nothing has been recovered from this present petitioner, Lordship, from concise position, Lordship. Only the statement of the Lordship, accused person, Lordship. That is under 67, which is not admissible at all, Lordship. May I pray, Lordship, that this petitioner may be protected, Lordship, because cognizance has been taken against those arrested person, Lordship. And he is only the defaulter of that notice, Lordship. He did not appear, Lordship, because of apprehension of arrest, Lordship. Since, Lordship, charge sheet has been already submitted, Lordship, now there is nothing for the investigation officer to, Lordship, call for this petitioner, Lordship. If required, Lordship, they can summon this petitioner during trial, Lordship. Otherwise, Lordship, this petitioner is ready to cooperate with the Lordship trial, Lordship, if, Lordship, he has been projected as an accused, Lordship, because the offence report, his name is not there, Lordship. So far, Lordship, order reflected on 29/1/24, Lordship.
Lordship, may I submit, Lordship? We have submitted one report earlier, Lordship. Kindly, Lordship, come to page number 8, Lordship.
Eight
That
of?
is 8 of our report, Lordship. We have submitted our report. In the first file. First file. First file to last one. Itu LCR aku file. This is the role of the Abdul Malik. Lordship, may I read? Arrested accused Ajay Kumar Paul had disclosed the name of MD Malik in his voluntary statement under Section 67C of MDPS Act 1985 that MD Malik is the receiver of the seized contraband 820 grams methamphetamine tablet in the instant case. Second point, arrested accused Ajay Pal also disclosed the MD Malik would have received 820 grams of methamphetamine tablets from Dhuburi. Lordship, point number 3, CDR of available mobile number so and so of MD Malik was analyzed. A lot of communication is found with the arrested accused Ajay Pal, Ajay Kumar Pal, so and Satish Burman, so and this communication also clarified the relation of Abdul Malik and arrested accused person. Now, Lordship, point number 21, Lordship. This is important, Lordship. That on the basis of above fact and circumstantial evidence, it is implied clear both arrested accused person, namely Ajay Kumar Pal, and Satish Burman have committed crime of illicit trafficking of huge quantity of 820 grams of methamphetamine tablet, too much more than commercial quantity, and violation of Section 8C cross C of NDPS Act 1985, punishable under Section 22C and 29 of NDPS Act 1985. They consciously involved in the illicit trafficking of drugs and constantly conflicted with the receiver of the seized contraband, namely MD Abdul Malik. Lordship, is proof their mental culpable stage, and Abdul Malik transferred 5,000 to the arrested accused Satish Burman on 2/8/2023. Lordship. So this is the role of the petitioner, Lordship. Lastly, Lordship, investigation is going on against him, Lordship. Kindly, the role of the Abdul Malik is there in the offense report also, Lordship, in page number 32. Lordship, kindly come to the page number 33 of offense report, Lordship. Prayer portion, Lordship. LCR.
Yes.
Point number 67, Lordship. Prayer portion. That the relevant documents and contraventions shall be submitted before your honor at the time of the trial of for making exhibits and complaint and craft leaves of this honorable court to file supplementary complaint, Lordship. Under section 173 CRPC, any after filing the complaint against any other found culprit in the instant case, Lordship. And page number 34, last para, Lordship. That it is also requested to the Honorable Court that investigation may be permitted to be continued in the instant case against namely Abdul Malik and Akhtar Hussain of Manipur and any other suspect named in the light of the seized cantonment. If any further evidence will come into light, it will be brought into the knowledge of the Honorable Court and supplementary complaint will be filed accordingly, Lordship. So investigation is going on, Lordship. If anything found the Lordship, supplementary complaint will be filed. And my senior argued this matter on 4/3/2024, Lordship. Argued this matter, Lordship.
That's why
After that, Lordship, case diary was called for, Lordship. Then, Lordship, on 25/1/2024, search is submitted, Lordship. Then, Lordship, LCR was called for.
Now, since the Lordship, the LCR is offence report is before Lordship, Lordship may peruse the offence report, Lordship. At this stage, Lordship, whether further whether custodial detention is required of this petition or not, that is to be taken into consideration because he is the defaulter in the 67 notice, Lordship. 67 notice, he has not appeared, Lordship, because of apprehension of matter, Lordship. No, the CDR, they have said, Lordship, they have received 5,000, Lordship. Whether that, Lordship, contravene, the core issue is whether contravene recovered from this petitioner or not, Lordship. If it is not recovered, Lordship, the burden not lies upon this petitioner to prove that, Lordship. It is recovered from him, Lordship. So for that statement in regard to 67, Lordship, Tufan Singh case is leading case, Lordship. It is not admissible at all, Lordship. I'll leave it to Lordship rest of it.
Lordship, earlier we have submitted one judgment, Lordship, my senior. I'm placing one more judgment that could be, Lordship.
You have 7.
Yes, Lordship.
Ajay Pal and
Satish Burman, Lordship.
Ajay Pal. and book. Partner. Report. That person's name Kumar Bhatt have come from branch of one human capital, much more higher than common one in 508 small c of the antigen and better also considered called it and it becomes at at a content together with most of provide some graphic IO or print for also seek out for continuity investigation against the petitioner and of one who are in suspect in the light of seized contract and this contract and also be by on the market guide standing outside for and see of guide from state of inspector versus Inam market and guide Vera of 11 data here port or there but in case of Samarnath, it also had was marked in number 105 and based on Iraqi 9. And the type number 1, but that up of above referred case of Savannah submitted that the event but nothing may be taken at the time of preparation or finally after completion track, but not this but I need to of but it's been so in that different number of contract
Highly obliged.
Highly obliged.
My lord, here in the last occasion medical report call for my lord. We have not received medical report today, my lord. I pray for another date, my lord. After yes, there is available here, my lord. 376, 354 C is there.
that is whether you want to return back the case.
No.
Then you will return because
No.
tomorrow they have to put
No,
an
no. My lord, my lord. We will return back the CD along with the and call for along with the medical report. That's reopening.
because medical report is required because cases of C7.
My lord, my lord.
Yes, sir.
Up to the CD along with medical report.
For MS,
अपना नाम तो कोई
hard not hard start. So you are updating.
Lot.
Yes,
After the
that's all. But it's not medical report now. That for proper Are you pure not or 59?
No.
19. 50 kit or 19?
Well.
19.
May page 438 bail application, Your Lordship. Case diary was called for.
My lord, here we have received a case diary, my lord, but without FSL, my lord. FSL not received, and my lord, co-accused is implicated his name, my lord.
Lordship, may I kindly say, petitioner is not named in the FI, Your Lordship. First of all, next thing, Your Lordship, the main accused, he has been already arrested, Your Lordship. 6.76 grams has already been, Your Lordship, recovered from him. And as per his, Your Lordship, version, the house of the petitioner is also raided by the police, Your Lordship. Nothing has been recovered, Your Lordship. And if Your Lordship come to, once the petitioner prepared an application before the learned session judge, Your Lordship, Jurhat, but rejected, Your Lordship. But Your Lordship may kindly come to that order, Your Lordship. My learned friend is saying that according to police, this FIR is lost by police. Police is stated that the arrested accused taken the name of the Your Lordship petitioner. But Your Lordship may kindly come to Annexure C, Your Lordship, the order of rejection, Your Lordship. Page 21, Your Lordship. Relevant portion is page 22, Your Lordship. May I read, Your Lordship? In his statement recorded during investigation, the arrested accused, though has not named the petitioner, Your Lordship. If he is not taken the name of the petitioner, Your Lordship, in his statement, Your Lordship, how police has stated that as per his version, he has been implicated, Your Lordship? According to him, Your Lordship, he has named the petitioner, but he has stated that he used to buy the drugs from various boys, Your Lordship, not from the petitioner, Your Lordship. And Your Lordship, it is 6.76, Your Lordship. Here it is also not mentioned, Your Lordship. It is the net quantity or it is the gross quantity, Your Lordship.
As it is the present petition.
So as per statement or as per the other decree, you are the king now.
My lord. These are the
You are the king.
As per Your Lordship?
As per the statement in method collected by the IO, you are the kingpin of the.
According to IO?
Because the question is that they used to collect those methods or whatever they used to consume also. The contraband was recovered from the possession of some of them. But they purchased it from you only.
No.
You are the person who supplied those things. They used to have consumed it and used to say for their money.
Lordship may kindly see, on the very day, the police raided the house of the petitioner, Your Lordship. Nothing has been recovered, Your Lordship.
Any other subject?
And one more thing, Your Lordship, according to my learned friend, Your Lordship, FSL report is not there, Your Lordship. So it is not as certain whether the Your Lordship sees things are Your Lordship. It is not.
Now cannot take the contraband whether the recovered items were the
Narcotics.
yes,
Your Lordship. But it is not from my position, Your Lordship. Nothing has been recovered
Not
from my
necessary,
position.
my lord. They are the organized, my lord. Organized crime, my lord. Where people are involved in this case, in such type of offences, my lord.
You correct.
But the subject by that is just what the that was by drug convicted one. Thus, it's not one how that from whom? But contraband and also for the purpose. It's important. Our friend and by for I find that for some I
CDB
Obliged. May I please, Lord? For 30 application Lordship, FIR is on page 13. Lordship, registered under Lordship 384 and Assam Money Lender Act. It's hard to understand the FIR actually. So, Lordship, may I read? বিনীত সন্মান সহকাৰে আপোনাক জনাওঁ যে যোৱা ইংৰাজী 1/5/2024 তাৰিখে বুধবাৰে আবেলি প্ৰায় 6 মান বজাত বলমা চাৰিআলিৰ সুতখুৰ শ্ৰী মদন বৰুৱাই মোৰ ঘৰলৈ আহি কয় যে 90,000 টকা সোনকালে নাম কাটি মোক প্ৰভিডেণ্ট ফাণ্ডৰ পৰা 4 লাখ টকা লাগে বুলি কয়। মই টকা 30,000 লৈছিলোঁ। 15 দিনত 1,500 মুঠ টকাকৈ দি থাকোঁ। এমাহত 3,000 আৰু তেওঁক মই এমাহত 3,000কৈ 3 বছৰ সুদ পৰিশোধ কৰিলোঁ আৰু মোৰ বৰ্জনা শ্ৰী বলিৰাম ৰাওৰ পৰা 6,000-7,000 টকা সুদ 4 লাখ টকাৰ লগত নথিপত্ৰ জব্দ কৰি লয়।
My lord, CD received, my lord. Here allegation is that, my lord, he is taken the loan to the poor person, my lord. He found poor person at a high rate of interest, my lord. Although he has no any license for such type of, my lord, but later on, even if they are not, and they also collected the voter ID, PAN card, etc. also. And if they are unable to pay the, my lord, amount, also petitioning part also they are, my lord. They have petitioned to pay the high rate of interest, my lord. This is the allegation, my lord, against the present petitioner, my lord. Here, several witnesses examined, my lord. All of them said that, my lord, he is, for a long time, my lord, he is doing this business, my lord.
Page 14 is the Lordship. He registered as money lender. This later on. When they came to know that he registered as a money lender, they filed this case. Actually, informant. Yes. Page 14. And page 15, he is a disabled person actually, Lordship. Page 15 is a disability certificate.
He got the month of on the year 29th.
Yes, yes. Lordship,
Prior to that, he had no.
No. Lordship, what happened actually, he is a disabled person. I have annexed the disability certificate, is page 15. He had a shop. Lordship, he sold the shop. Then his informant took rupees 90,000 from him to invest in a pig farming, Lordship, in village. Later on, they did not return the money. And when he registered as a money lender, they filed the case under money lender act. When they came to know that he registered as a money lender, they filed the case.
That in that case, before your registration as a money lender, started your business, doing all these things, taking interest, giving loan, and as far as that also obtain the other card, PAN card, etc. from the person who took loan from you. So what, why that kind of effective?
Lordship, actually they took money for other purposes, not as a, to give profit. I have mentioned in the petition that they took rupees 90,000 from me when I sold my shop. I had a shop in York Town, repairing TV, and because I am a disabled person. Then I sold the shop, they took rupees 90,000 from me. Then did not return, and they took money and 90,000 to invest in the pig farming, and they promised to give me return with profit. It is not taken for interest actually.
Yes, then it is
Hello.
just a sub- not and it code is also applicable against you because it cannot take money even from the provision fund of someone or bank account. That kind of
Actually,
not only the yes, sometimes have some purpose they have to take in the people. I think that they have that I would deny. But the activities they have done by you are as permitted. Not so
it will not affect 384. Actually, there is a monetary transaction.
I mean, 384 allegations are there. That's why as per
Monetary transaction is already there. They have monetary transaction between them.
witnesses, how you dealt with those persons while expecting money from them is there in the imagery. You even threaten them to try to collect all the Aadhaar card, money card, the PAN card, etc. Then you use those things, withdrawn those money from their account, even from the provident fund of some person. This is kind of activity that is there. I mean, anyway,
Person is not the person is disabled person. He
what could disable are the things. Okay, I would activate the there are S8 S4
access Bora.
Bora. Hard. Bora. Right. That's some. And go. And for fun and one after it was some kind of purpose. We told
Shop.
shop.
Shop. Yeah. Mobile TV, television repairing software. In the town of Tiop.
That someone that but does take when you think that present on opening at some point of that by out where the most the and was undiluted by the not by top and what is done that and the name of the affected number and some purpose not are up there and and that one of Assam market from that annex that drive that itu apa ya? I know. Let's say it's that.
No, 25 only.
May I please, Your Lordship?
My Lord, CD not received.
My Lord, I am an interim. I appeared after the interim was forwarded, Lordship.
You are already applied.
Lordship, I have appeared. Allegation under Cattle Preservation Act, Lordship.
You have not received
The CD not received.
when can we call?
My Lord, after vacation, my Lord, immediately after vacation, my Lord.
18, another matter is fixed from the CD on 18/7, Lordship. Lordship.
Out of same.
Same FIR, Lordship. Yes, I am
case?
Tamarhat case. Tamarhat case.
When?
It is Tamarhat PS 26 of 2010.
Mine.
Another similar matter is there.
My Lord. May I please, Your Lordship? My Lord, in this case,
27 you are
in this case, Lordship, allegation under section 13 and 14 of Assam Game and Betting Act, Lordship. Lordship, my name is not there in the FIR. The FIR person who is involved and from whom recovery was made, he is arrested, Lordship, and he is in custody, Lordship.
Who are you? Who are you? You are driver, owner.
No, Lordship. Games and betting. I am a
Games and
Lordship. I am a mere house construction worker, Lordship. I am not involved in the case. My name is also not there in the FIR, Lordship. Even then, if police doubted my involvement, no notice was given to me, Lordship. 41 A notice was not given to me, Lordship. Lordship, allegation regarding mere IPL gambling, Lordship. Minor offences, Lordship. I am not given opportunity to appear before the IO, Lordship. I may be given the opportunity to appear before the IO while cooperate with the investigation. I am not given 41A notice, Lordship. And Lordship, one more thing is that, my Lord, I am a house construction worker. I fall down from a building, Lordship. I am seriously injured, Lordship. I have annexed the medical papers also, Lordship. Page 14 onwards, Lordship. right side rib cage is broken. I am bedridden, Lordship. And from that neurological problem has
If
also.
you are bedridden, how will you appear before the IC?
Lordship, if Honorable the court directs me, anyhow I will appear with the help of other person.
Case that you have received, my lord. My lord, here in this case, my lord, yes, he is not named in the FIR, my lord. But my lord, other witnesses, lordship, in the case diary, they have implicated one, my lord,
Uttam Das.
Uttam Das, lordship. And he has been arrested, and from his possession, lordship, some mobile phone and my lord, some money has been recovered. Uttam Das was implicated, and he is also associated, my lord. That is implication, my lord. Other independent witnesses, lordship, from the case diary, they have implicated only Uttam Das, my lord.
I am not Uttam Das, I am Nitu Muni, Lordship. Tutu Muni.
No.
Uttam Das. Yes, Lord.
Uttam Das, my lord. Uttam Das has been arrested, my lord, and he is from his possession of mobile phone and money has been recovered, my lord. Thank you, my lord.
Highly obliged.
Lordship, your disposal, lordship.
Officialization. May I please, my lord? Mr. Case diary was called for an FSL report.
CD receipt, my lord. Here CD receipt, my lord. FSL not received, my lord. Here 4 numbers of small container, my lord. Suspect is heroin. Was seized from his possession, my lord. Container, and from the statement of the accused, my lord, it also reflected his involvement, my lord.
0.22 grams, my lord.
No, what is the subject? Is it any involvement?
My lord.
Involvement?
My lord.
And section
from his
is, my lord,
possession also recovered, my lord.
a small quantity,
From his
my lord.
possession, my lord.
Not from my possession, not from my house, my lord.
From his house, my lord.
And 0.22, my lord. That is 21A, my lord.
0.22 grams. Is from his house, my lord. And statement of the lord.
We consume, my lord, in future, my lord.
I have to take my seizure list.
It's a small. Yes, my lord. There is small quantity, my lord, 21A, my lord, and we consume, my lord. Yes, my lord, in future, my lord, I will be not, my lord, I will not consume, my
You are
lord.
not already consuming.
My lord.
That is the problem.
Yes, my lord.
127 suppose not be consumed.
My lord, I will give assurance that, my lord, he may be
30%
rehab center, if, my lord, that is, my lord, that is, my lord, curable, my lord.
But he is not, I mean, he is not showing any center or, I mean,
that consume.
symptoms, etc. or
Consume.
neither he was ever admitted in the rehab center.
Yes, my lord.
From where from you are saying that he needs to be kept in the rehab center. He's not having, not consuming. That's it.
But my lord, says also, Sejal list also shown, my lord, nothing, my lord, commercial only 0.22 grams, my lord.
Admitted not.
Yes, my lord. Yes,
Registered under 21.
yes, 21 in.
Admitted not. What? Speak a little.
Yes.
But, but,
My lord. My lord, container 4.4 grams, my lord. Without container, 0.22.
Obliged.
here, morning hours have submitted one I, one I.
My lord, to impede the respondent, my lord. To impede the respondent, my lord.
Yes, Lordship. There was a direction, Lordship, on last occasion.
to implead the informant, or 5 to file affidavit if any. Lordship, here the matter has already been settled between the parties. Sections are 498A and 313, Lordship. So 313 is exclusively triable by session, Lordship. And someone has already been issued by the learned JMFC TU, Lordship. And the next date of appearance is 1st July, Lordship. Here, Lordship, after receiving summon, Lordship, Sarcited case, Lordship. PIC case is pending, Lordship. And on last occasion, this is the second round of application, Lordship. On first round of application, Lordship, Lordship is directed to appear before the court below, and there was a direction, Lordship, page number 38, Lordship. Sorry, Lordship, 34. And relevant portion is, Lordship, 36. That, however, no coercive action shall be taken against the accused petitioner till 21/5/24. That means the next date of appearance. And accordingly, I have appeared, Lordship, with a petition, Lordship. But that petition was, that petition was not allowed, Lordship, and I have not pressed that petition, Lordship. Because court view is that I was not allowed to go on bail, Lordship. That is why on last occasion, Lordship, I was asked to implead the informant, Lordship, as respondent number 2, Lordship. So I have been filed, Lordship.
That is not in the record today.
I already come up.
The notice will
Not yet filed.
Lordship, I have filed, Lordship, but there was a there was a mistake, Lordship.
Whatever it is, we are not.
After some time, Lordship. কথাই আছো বুলি কৈছে section number. On the way, Lordship, after 10 minutes, Lordship. And then, Lordship, the matter may come up on tomorrow, Lordship. The next date of appearance is 1st July, Lordship. And there is a strict direction, Lordship. Otherwise, I will be put behind the custody, Lordship. Tomorrow or day after tomorrow, Lordship.
This is out. Tomorrow, same but
one
I have come out in address because my
person at 28.
Lordship,
we are having another meeting on that.
Lordship, if allowed, Lordship, then the informant can file one Wakalatnama, Lordship. Then the informant can file one Wakalatnama, Lordship.
That the one counsel appeared on behalf of her, but the I is not received it now. So that's why in the morning hours you have paid, I cannot. And I have already put the I has to be called for. So now he is saying that I is not.
I has not been received, Lordship. Then matter may come up on, Lordship, day after tomorrow, Lordship. Because on 1/7 my prayer will not be considered, Lordship.
Okay, but we don't have to pay.
And warrant will be issued, Lordship, on that
Okay,
day.
let the warrant be. Well, listing at 20.
28. 28.
Please, Your Lordship. Lordship, I may be allowed 1 day time to take steps upon respondent number 2, my lord.
Now we have not taken.
My lord, I have missed, my lord. I am sorry for that, my lord.
For MX.
R.R. Bora.
Other. come up after petition.
Lordship.
Who will retain the case there?
Huh?
Who will retain the case there?
Is there is
Receive, my lord. Who will retain it?
written? That's after
My lord.
15/7.
16, my lord.
Obviously.
People. No.
May I please your Lordship? Lordship, in this.
No,
Lordship,
my lord, no, I mean, my lord, the matter is pending because they are yet to pay the 20% of that amount, my lord. It is NIA, sorry, not Negotiable Instrument Act. I am saying NIA. Negotiable Instrument Act, my lord. So we were the complainant. A judgment was passed in our favor, around 30 odd lakhs, my lord. They had to pay, my lord.
36 lakhs.
36 lakhs, my lord.
And
2015 check, already 10 years elapsed. They came in appeal, my lord. In appeal, it has been 3-4 years probably where a direction was given that deposit 20%, my lord. 20% amounts to 8 lakh, my lord. So today I am told by my friend that they are depositing 5 lakhs.
5 lakhs. Lordship, we have already prepared the draft in favor of the registry of Lordship. We are depositing today during the course of the day, Lordship, 5 lakhs.
That may be recorded, my lord.
And Lordship, another.
This court directed because that is the mandate of
Lordship,
148.
peruse the order is 24/3/2020.
There was an interim order passed in their favor, staying the conviction execution of the order, subject to the condition that they pay 25% of the compensation amount. And since they did not pay, my lord, this interim order was subsequently vacated by this court. And now, my lord, today they have come with part payment of 8 lakhs, that is 5 lakhs. Already vacated because they have not complied with the order.
Interim order
Interim
vacated
was
on-
subject to payment of that.
Interim order vacated on 21/6/2020. Okay, thereafter we have submitted the medical documents also, which shows that the petitioner was admitted at Delhi for around 2 years, Lordship, and amputation was also done, Lordship.
As on date, my lord, may only, my lord, for today, your lordship may record that they are depositing it, and then we are at liberty to withdraw it, my lord, from the register.
Lordship, another aspect, Lordship, this petition was filed on 24/3/2020 during the lockdown period, Lordship. We have taken the permission from this. Since now the Arunachal has permanent bans, Lordship, this matters pertaining to Arunachal, Lordship. Can it be transferred?
Because it was Chief Justice by virtue, it is they who have sought the permission. Now my client has engaged advocate from Guwahati, in Guwahati. Again they will have to engage. Now my lord, first let them pay the 25% and then whatever effective order they need, it is only thereafter.
After transfer, both can be over.
No. No. Now to, my lord, at least today they have come up with 5 lakhs, at least that may be recorded that they want to deposit it today, my lord. The number is the photocopy. No, I mean, photocopy record order. Return. Your lordship may record the number and everything and then return it. Hey, the photocopy. Draft. Draft is better, my lord. Let's check again, may get this or not.
কে করিতা
My lord will record part payment. This is part payment because
we are supposed to pay
part payment, my lord. Lordship fixed the matter in the month of August. Lordship. Pardon? Of August 2015 check. Yes. 10 years. 10 years, my lord. 10 years. Anyways. অলপ পিছত দিয়ে 15 আগষ্টটো স্বাধীনতা দিব পিছত My lord has given my lord liberty to the respondent. I am deeply obliged. I'll oblige.
My lord, here one submission, my lord. Item number 26, already my lord order passed. Here information is that charge sheet submitted, my lord. Item number 26 is there, my lord.
It is fixed on 18 as
For
CD,
CD, my lord.
for CD.
It was called for CD, my lord. But information we have received that charge sheet submitted. Page in interim, my lord. Then my lord, charge sheet number is my lord 31 of 24, dated 31/5/24.
I am on interim. In the meantime, I will appear, Lordship.
Lordship.
15 days, Lordship.
My lord. Oblige. Oblige.
Oblige.
After my CD is received, but it may be retained, my lord.
Item number?
Item 15. 15, my lord. CD received, so CD they may retain. Earlier order is there, my lord, 27.
LCR received.
No, LCR is like CD was also called for, my lord. Along with the CD, my lord, it is a defined police station, my lord. It is Goroimari, my lord, 90, 89 of 2023, my lord. Lordship, kindly go to the order dated 27/3, my lord.
My lord, here, my lord, in the morning I have informed from our office, it is informed that the case has taken back, my lord, for upgradation, my lord.
Maybe.
There is no any order. No.
No. Charge not that.
Charge not that.
No, sir, not charge. Then upgraded case there you may produce after vacation any day.
Taken back, my lord, to the it was from Goroimari, my lord.
Goroimari 89 of 2023.
Scan copy to কি হইছে দিতে হলো?
Scan copy to LCR. দুটা proceeding আছে। NIA তো বলে আমি FIR দিতে দিব। My lord? Yes, ma'am. Yes, ma'am. After vacation?
No. 24.
Alright.
NIA case perhaps.
Item number
NIA case,
my lord, one item, that item 38, my lord.
My lord.
My lord, after vacation, you will give the date, my lord.
My lord.
আপুনি গিফ্ট ল'ব লাগে
ঠিক আছে কিমান উপকাৰ কৰিছে মাতি এইটো আহি বেয়া পাম মোৰ লগত একেলগে মাতি আনি অৰ্ডাৰ কৰিলে ভাল দেখি নে
কিবা হেৰি কষ্ট ভিতৰত আহিছে কৰবাত
চাই লৈছে কেনেকুৱা চিটি আহে কি কিমান আছে আমি নাই প্ৰাইভেট পাৰ্টি
Thank you.
ফোন নম্বৰ লৈছে
কাৰোবাৰ ললি কাৰোবাৰ ললি
ৰেকৰ্ডত ফোন নম্বৰ দিয়া নাই ফাইলিঙত
মই গম পাইছো তাৰ পৰা চেক কৰি লৈছে
আমি দিনভৰ ৰখি থাকোঁ পাঁচটা বজালৈকে আমি সদায় থাকোঁ
উঠিলে যাতে হৈ যায় বুজানে
Gracias.